I think we'll get going here. I think everybody should be here wanting to talk about patents. If you're not, if that's not what you're wanting to be listened to for the next hour, then you better eject now. So again, I want to keep it informal. It's hard to do in Zoom, but let's try it if we can. But anyway, I really wanted to frame this in terms of kind of from the perspective of a new client coming into my office and what those questions usually look like, what that conversation, how that goes, and hopefully answer those bigger questions. At the same time, answering questions you guys actually have. And so having conversations before with, startups and small businesses on a pretty regular basis, I generally know what those questions are. But anything specific, I'm happy to go down any tangents that exist here. So high level and most everybody, I have a list of the people who are attending or registered, and a pretty good mix of people there. We have some startups, we have some small business people, we have people who are in tech transfer that are wanting to kind of get more acclimated to the startup world. We have people who are in large companies or who used to be in large companies. So it kind of runs a gamut. So, most people probably have a pretty good feeling for what patents are in terms of just high level what they do. But just so we're all on the same page, patents are one of the big four in terms of intellectual property. They are probably the big kahuna in that way. Patents protect innovation. They protect technology, innovative designs, functional aspects and structural aspects of devices, methods, code, all sorts of things. Things like writings, paint. Secret doesn't really have. It is to patent. Right. The first really point and what functionally do I use them for? And everybody understands that you use them. Sounds like audio is dropping in and out. Okay, let me turn off the video. That's too bad. Give me a second here. Try that again. All right, so I'm going to back up to the beginning of this slide. So people come into the office, typical question. First question is, what do they need a patent for, or what's it good for? Why should I bother with it? I know they're expensive. I know they're hard to enforce. So baseline starting point is of course they establish a moat. They're a right of exclusion. You can use your patent to enforce it against others who are infringing on your product or your design. That's kind of level one. Now, I guess the big thing I point out is that you're not getting if you're a small company or a startup in particular, you're not getting that patent for yourself right now. You're getting that patent for your future self, or potentially a future acquirer of your company. You as a startup that might have 2 or 3 employees, you're not going to go take on Google or Facebook or Apple or Google or whoever it is. You're really taking out an insurance policy so that when and if you grow into that larger, 300 to 500 pound gorilla, you have an opportunity to protect your patents. And I will say most companies generally do a pretty good job of respecting patents. I mean, at least in the United States, they will actively, they do due diligence. They look where patents are. Now they will certainly work around them creatively, but they tend not to willfully just go out and infringe on patents. Now, I'm not saying that's a rule. There are certainly some that do, but I think people will be a little bit surprised by how much effort companies put into actually trying to avoid other people's patents. The other kind of second level or second order consideration is the kind of defensive tool model of patent protection, which is really basically analogous to the Cold War, which is, party A has a set of patents, party B has a set of patents. Neither one wants to go after the other, because if they do, then the other one will sue them back, essentially, and you kind of set off a patent war or a battle. So if you have two companies in the same industry and they kind of overlap in rights, that kind of leads to a standoff. And the key is you don't want to be in that industry and not have patents, because then everybody can kind of come at you. So that's kind of the I always call it the Cold War version of patent rights. But from a very practical perspective, not really from an infringement or enforcement perspective, I guess it is indirectly, but investors prefer them. About every time you're talking about a venture capital guy wanting to go invest in a company, the very first question I ask is, do you have patents, or do you have patent applications? And then before they invest any large amount of money, they're going to want to do due diligence. They're going to want to look at the patents. They'll hire a patent attorney to analyze those patents, and it's pretty much just uniform across the board. That's what takes place. And then, obviously related to investors is just kind of the next step to that is the actual acquisition. A large company comes out and buys a small company for a nice chunk of change. That almost always involves IP at some point. Now, it's not always patents. I also want to be clear that you don't have to have a patent to operate. There are plenty of companies that do well without patents. But if you're in a technological space that lends itself to patenting, you definitely want to have a patent strategy. And so that's something to keep in the back of your head. So I guess with that background, just a few statistics I'll throw out there quick. Most of these are, I think, been pulled from Forbes at some level, but just some data. On average, tech startups receive about $535K more per round of investment per patent. And then 80% of startups that receive venture capital hold patents. Now, I will say the stat doesn't clarify whether that's U.S. patents or foreign patents. I think that's probably any patent. General point is it's a large number. And then startups that experience high growth are 35% more, or sorry, startups with patents are 35% more likely to experience high growth. So you can't see my hand waving, but I was using air quotes there. High growth is not, I don't know what the term means exactly, but I do know it's a defined term for this statistic, which is not a problem to quantify. But now the last statistic clearly is, I'm not going to suggest that is clear causation. There's probably some pretty just straight up correlation there, where a company that has a lot of innovation going on, they are just generally more likely to experience high growth, and because they have a lot of innovation going on, they are probably generally likely to get patents allowed. So it's not necessarily it's a chicken and egg question. And but there's certainly correlation there, and all things being equal, you'd rather have patents than not have them. So that's just generally high level justification when people talk about it or come in and ask me about why we need patents. But I guess for the purpose of this talk, I just want to walk you through the rest of what that conversation looks like. It starts out with what can you protect with a patent, what kind of technologies or types of subject matter can we actually patent? And I have a few examples here in a few slides to go over that. Then immediately we start talking about what does the patent process look like, kind of a step by step. How does this all work? And then with that, I try to kind of pepper in some thoughts in terms of cost savings. I do have a specific slide for it, but that's really kind of a topic that is kind of interlaced through the entire conversation. And then, provided we have time, I want to at least touch on some of the standards related to getting a patent. I think it's important for you to understand what are some of the threshold requirements for just getting through the patent office and to issuance. And then as you go through with it, what can you actually in a tangible way use it for? So to get going on that, what do patents protect, or what can you use patents to protect? There are three types of patents in the U.S. system. There's a utility patent, there's a design patent, and then there's what's called a plant patent. I'm not going to get into plant patents. It's an extremely nuanced area of patent law that I think in my entire career, I've filed one. And so unless you're a startup that's working in the ag space, developing new plant types, you really have no need for it. But generally, utility design, those are the two major ones. Utility is probably by far the one that's most recognized. If you've spent any time on Google Patents or searching the USPTO's database, that's usually what you're going to find. But a utility patent, kind of protects what it sounds like, but it protects any device or invention that has utility. So it's really getting at the function of the invention, but it protects new, useful, non-obvious machine processes, articles, and that kind of sounds like this part does. There's some and that's true with a few exceptions. Of course, some of the exceptions are kind of well known at this point. There are some exceptions as things relate to genetics. In particular, you can't go out and patent a human being. You can't patent math. You can't patent a naked algorithm without other technology built around it. So there are limitations on what you can patent, but by and large, almost everything is eligible for patent protection. It doesn't necessarily mean you can get a patent, but it's at least kind of the lesser known design patent is really directed at covering and protecting ornamental designs of articles of manufacture. That's a legal way of saying designs, but it used to be really popular, and then it really lost some of its flavor, and then now it's coming back, and that's because of kind of some changes in the law that make enforcement quite a bit more easy. But at any rate, both the utility and design. One thing I want people to understand is that the scope of your protection is ultimately defined by claims, and the claims are they work in different ways, and we'll talk about that in the next couple slides. But it's not just the drawings. Well, in the design it is, but it's not the title of the application or the drawings in the case of utility. It's the claims, and so it's very specific, and that's something that's misleading. And anytime patents are reported on in the media. And so I want that to be clear. The claims, you're not capturing a high-level concept. You are capturing a very specific chunk of protection that's limited by the claims in the application. So, just to take you through a couple of examples, and these are examples that actually have been clients of mine. Don't worry, this is all public information, and it's all published. In both cases, I have their permission to use the examples too, but. So the first one is, let's see here. I can get there. I'm just going to run through these examples so you have, so it sounds like there's some other problems with the video. So that's too bad. I'm going to keep going. And yeah, there will be recordings of the video, so that you'll definitely have that. But I guess if you're able to tune in, keep tuning in. If not, you will have a recording. So I'm going to run through these examples and then kind of talk about them as a collection. So the first example here is a what they call a convertible bike. It's a little kid's bike. If anybody here has kids, they've probably heard of the brand Strider bike. So this is one of their newer products. It's a balance bike. Well, the configuration you see on the screen is a balance bike. But there's a little piece that can be taken off, and so it's a stand that you can balance on and coast on, basically. And then as your kid progresses, replace it with a pedal assembly, so you can convert the bike into a different form. And so clearly that has some design aspects. There, you look at that, and yeah, there's some interesting pieces that might be unique from just purely the design perspective, but it's also clearly got some interesting functionality. Most bikes don't convert like that. And at the same time, there are some very common features that you see in all bikes. So what is it we can do creatively to kind of wrap good patent protection around that? And similarly, and this is, I always use this one as kind of a funny example. And all these examples are meant to be very, very simple. I chose these as opposed to really high-end technology because I don't want anybody to be limited by the technology. So this is what we call the, lovingly call the pie turtle, and it looks kind of silly, and it kind of is, but it really, what it is it's a design for a pie carrier. And the idea is you take this pie turtle, you put it in your trunk, and then you transport your pie on your way to grandma's Thanksgiving dinner. And from a functionality perspective, I think we could probably all agree that might be a little hard to capture, but from a design perspective, there are probably some pretty unique design elements that you can see. And then maybe surprisingly to some, there are software apps, and I just used some icons to throw in a bunch of well-known ones there. I didn't really show the actual screens, but and I chose this because each one of the examples that I've chosen, the bike, the pie turtle, and the software app, they patents and design patents. So and designed of devices design. You think we can reasonably get utility claims, and do you think we can, or do you think we might need to just stick to design application? But one thing I want to point out, and this part is kind of using this kind of two birds with one stone to introduce you to the idea of design patents in addition to utility patents, but also give you an idea of how they both operate differently. So, with respect to utility patents, utility claims are defined by the text that comes in the claim section. So you go through a patent. At the end of the patent, there's a section called the claims, and there's a lot of words in there. There's a lot of legalese, and you go through that, and that essentially operates like in the real estate, as a real estate analogy, like the plat map, if you're familiar with real estate. But at the end of the day, in order to infringe that patent, a competitor has to be performing or selling a device that includes all of the elements in that claim. So if you look at the middle of the page there, what is claimed, a competitor has to do all of that in order to infringe the patent. So obviously you can see when you look at that, that's quite a bit more complicated than just the title of the patent, which is conversion bicycle apparatus. So keep that kind of detail in mind when you're thinking about patent rights and how specific it can be, and don't be misled into thinking that you'll just have a general patent on any of your concepts that you put together. And that's really kind of defines your claim scope, and then the mirror part of that is it helps define whether or not infringement occurs by a competitor. Now, in contrast, the design application is defined. Your claim scope is completely defined by the drawings that you put in your design application. There are no written claims. Actually, solid lines for claim subject matter and dotted lines for unclaimed subject. Quite a bit of coverage with a couple, either a single design application or maybe even a series of design applications. And by using those tools, you can get pretty good claim coverage. And the other interesting piece about design related designs is the standard for infringement is a bit more clear to understand. It's basically, I provided the actual case law there, or standard, but it really just comes down to, does an ordinary observer who understands or familiar with the art in general, when they look at your patent and when they look at the competitor's product, do they think there's infringement? That's really about it. And in the context of pie turtles or pie carriers, pretty much anybody off the street would be considered an ordinary observer familiar with the prior art. So, it really starts to be a very comparing drawings to products type of exercise, whereas the utility patents are, the process in determining whether or not there's infringement is much, much more complicated and really kind of beyond this conversation. But when you just look at the language in that on that page, on the previous page, you can see why it's hard to understand. You read through that, and even a pretty well-educated person, in fact, different patent attorneys can look at that same claim, and that's kind of what happens in litigation. They will look at that claim, and they will have differing opinions on whether or not a particular product infringes that claim. So designs provide narrower protection because they are defined with the drawings, but they are often easier to work with. So I guess kind of putting all this together, at the outset, and I'm really focusing on the utility and design at the outset, which might seem a little bit odd, but it's really because that's how a lot of startups and small businesses, when they come in, this is how we start the conversation. Like, well, what kind of protection could we get? And then we kind of drill down from there. One major point I want to point out is I'm not suggesting you have to pick one. We have the utility that we were able to get issued. We also were able to issue several design applications on the same design. So it gives you some nice tiered protection. Designs can be easier to do, so they tend to be cheaper. And I put little dollar signs on everything where I suggested you might be able to save money. But and as I mentioned, they can be easier for enforcement purposes. So they do design to utility protection and should not be ignored. And a lot of attorneys don't utilize them enough. I think it's something that can provide quite a bit of value for quite a bit less money. So I guess with that, okay, you understand high level what you could potentially get patented. Now, what the next question is always, okay, well, how does this all work? It's you're using a lot of words and you're talking fast, but how does this process kind of how do we go through that? And it really starts with, conception of the invention. So this nice little flow diagram, and I have slides for all of these, and I'll try to zip through those for you here pretty quick. But, starts with the conception of the invention, and from that point, you go to invention disclosure, whether that's a formal process or informal process. An invention disclosure, I don't mean public disclosure, I mean a disclosure to your attorney. Start off with a patent search to help understand what is actually out there. And then, although it's not required, most startups and small businesses would start with a provisional application, which is a nice placeholder, which is the regular application you're familiar with. And then either at the same time as the non-provisional or after the non-provisional, you would start entering your foreign filing efforts. And so I do have slides for each one of those to help you understand what that involves. Invention disclosure, or here I call it the invention disclosure form. I really will just provide you this. It's basically a form that, and each patent attorney probably has their own, but it really just helps you systematically capture your inventions. And so if you're a startup, you may have an invention, but you may have 3 or 4 coming down the pipeline. It just really helps you start getting the process of mining your operations intellectual property. But it does more than that. It also helps guide your thinking a little bit. I think most inventors come to the table and they think, well, I have this invention and it does X, Y, Z. Let's go file a patent on that. And that's a good starting point. But you really want the inventor to start thinking about other alternative, or thinking about alternatives. What other ways could you do this that make financial sense? And that really what you're getting at is you're trying to help cut off competitor workarounds. So if you file a really narrow patent application on some widget that does a particular function in a very narrow way, and you may get patent protection on that. Well, if a competitor can easily work around that, it doesn't make that patent worth very much. So you want to really kind of expand your protection by working through that thought process. And then at the same time, it helps you aggregate and understand what the prior art has. So the aggregation is important because any prior art that you're aware of, you actually need to file that with the USPTO when you ultimately file a patent application. And so this form kind of helps you keep track of that in a nice streamlined way. And I also add, it just helps you communicate with your patent attorney. I mean, just simply having this form and having this content in it, it helps you, at least at a bullet point level, allow you to quickly communicate with your patent attorney. Anytime you can quickly communicate with an attorney, it's a good thing because that usually reduces costs. So that's kind of a starting point, and that is mostly on the inventor side of the table. And then from there, you usually go into the patent search. What we're really trying to do is replicate what the patent office is going to do. So we usually, if things are well structured, we usually will take that patent disclosure, obviously in conjunction with conversations with the inventor, and then we'll put together some search terms or search queries. And really, we're just, again, we're replicating what the patent office does, but we're really just it's an insurance policy. We're trying to really try to find what we call knockout art, because we'd rather find that art now as opposed to finding it after we've filed a patent application, where you've spent a lot of time, money, and effort to get that filed and push that forward, and then we find out after it's at the patent office that there was art out there that is doing exactly what you're contemplating. So we try to do that at the front end. Now I would say that beyond the knockout art situation, most times I would say probably about 8 to 9 times out of 10, you don't end up finding knockout art. What you find is art that's kind of in the vicinity of your invention. And that's actually really advantageous because that helps you craft your patent application in a more distinct way. So your patent attorney is actually really looking at the art. They know what you're working on, and then they craft the application to really highlight the differences between what you're doing and what the art is. And if you didn't have that art and you weren't aware of it, you would kind of glaze over some of those distinctive points. So I think it really, in almost all cases, it adds value. Now that said, I think most inventors are usually technically savvy in some way, and I think inventors this is one area where I think inventors can get pretty far with their own efforts. And Google Patents is great. I think if an inventor really systematically goes about that and spends several hours on that, varying search terms and things like that, they can get away. And I think most patent attorneys will work with you in terms of giving you some tips. I certainly do. Now, a good professional patent search is probably hard to replicate because we have patent professionals that really focus on doing searches, and I have a guy down the hall that does this all the time, and he really focuses on class-based searching, which is how the USPTO breaks up their patent or breaks up the inventions, and that just is far superior to the keyword searching method. So you just cover a lot more ground and a lot more focus more quickly. But inventors can get a long way, so don't discount that. And I always tell people to go get on and do a patent search on Google Patents before you really start spending money anywhere, because you may run across your invention right away, and then that just saves you a lot of time and heartache. So after the patent search, typically, again, next step is provisional application. Provisional is a bootstrap. It allows you to bootstrap, and I'm pretty much throwing that word in there because it's a nice keyword that is thrown around in the startup universe quite a bit. But it truly is. It does allow you to do that. It also allows you to quickly avoid a barring event, which we'll talk about those in a few slides. But really, the big advantage and why most take advantage of it is it's less formal, and because it's less formal, you can usually do it faster and cheaper than you can a non-provisional. And the other nice advantage is you can file multiple provisionals. So if you can have an invention, have met with a patent attorney, yep, you're going to go forward, and then you go ahead and file a provisional, and then 4 months later, your team decides they're tweaking the technology. Well, you can go back and file or essentially take that original application and kind of augment that or supplement it to cover the new variations. And that's pretty easy to do in the provisional stage and a lot harder to do in the non-provisional stage. So it gives you kind of a year to kind of iterate a little bit and capture those in a series of provisional filings. So that said, you file one or more provisionals. You have a year then to get that on file, or get the non-provisional on file. And then I would also add that, I think a lot of attorneys at the provisional stage will work with inventors. I think a good savvy inventor can usually get quite a ways to provisional. What I usually would model, I mean, if an inventor comes to me and say, hey, Matt, I want you to write this whole provisional from page 1 to page 50, no problem. But what I often find, especially in the startup small business case, is that they would like to do the first draft. So what I usually try to provide a template, and I let them kind of go to town. They do the first draft, and then they send it to me, and I'll give some feedback. Maybe I'll do another draft, or I just take it from there and finish it out. And that I think that's common sense. It's going to save some time, and in this universe, that time is money, and so that's usually advantageous. And so if you start adding that up with all the other things we've talked about, you can really start to get some pretty substantial coverage without having yet really invested a lot of money into the effort. So then obviously we've already mentioned the non-provisional, but again, has to be filed within a year of the first provisional. The non-provisional, the way this works, in a very specific sense, is that non-provisional claims priority to the provisional through a priority claim. It's like in the first paragraph of the non-provisional that allows you to, if everything is done right, it allows you, the non-provisional, to effectively be treated as though it was filed on the day the provisional was filed. It's much more formal than the provisional, and because of that, it does just cost more money. But hopefully by this stage, this is a year into it, hopefully there's been enough due diligence, the market's been tested, that hopefully at that point that no decision comes up in about a year from the provisional, you're kind of ready to push forward. One point I do want to make, so I don't want to mislead people. If you do introduce new material in the non-provisional, which you can do, there's no prohibition against that. But if you do, just keep in mind any claims that are directed to that new material, the effective filing date for those claims will be the date that the non-provisional is filed, and not the date that the provisional is filed. So what that means is you can actually have a non-provisional application with a bunch of claims in it, similar to what I had showed in the earlier slides. And they each have kind of different effective filing dates. And that's not a problem, but just be aware of it. And then one little, I guess, tip that I think a lot of attorneys kind of glaze over is that in the provisional filing fees, the non-provisional filing fees are quite a bit more expensive than the provisional. But in the non-provisional, you can actually delay the payment of those fees for a few months. So I typically would recommend with startups and small businesses who are maybe like, well, let's get it filed. You can usually wait at least 2 months. You can actually wait up to about 8 months if you pay extension fees. You can delay the payment of those fees, because there are times where 2 or 3 months matters quite a bit, and you might just be right at the cusp of getting some investment money come in. And you say, well, you know what, let's not pay the fees. Let's wait a couple months. Let's see if this pans out. And if it does, we'll go forward. If not, we'll let it go abandoned. So it's just another knob you can turn to help conserve resources. And so then that brings us to foreign filing. This is where things get real. Foreign filing gets expensive really quick. So the very first threshold question is, do you really even need foreign filing? I think if your end goal is to ultimately license this technology, you need foreign filing. Usually when companies buy patents, the first question they ask is, do you have a U.S. patent, a German patent, and a Chinese patent? And you pretty much need to establish those. If you're operating and you're just building a company, you need to analyze whether or not it makes sense. And that really two questions is where you're manufacturing your product, where's your manufacturing at, and where is your market at? So if your market is in the United States and you're manufacturing in the United States, and you really have no intention of growing beyond the United States in any significant way, in the next couple of years, foreign filing maybe doesn't make a lot of sense. I mean, certainly if you can get foreign protection in places like Canada, maybe Mexico, Europe, those obviously would be great. But if it's a cost benefit analysis may suggest you don't. The other, the middle of the road is you're manufacturing in a foreign country, like China, for example, and your market is the United States. Now that's kind of a you're right in the middle of the fence, because one aspect about U.S. enforcement is that you can block imports from coming into the United States. So you can get kind of a foreign flavor with a U.S. application when your market is really limited to the United States. Now, so that's kind of a coin toss. And it also depends on where your manufacturing is and how easy is it to enforce patents in that area. Because, if you're manufacturing in a foreign country, that typically is where you'll start to see ripoffs, just because that's where the technology leaks out and inventors go different ways, and or not inventors, but manufacturing staff will go different directions, and they end up in different manufacturing plants making your product in a few weeks after you started manufacturing yours. So that's the middle of the road case. Now, the case where it really screams foreign filing is when your market is global and you're manufacturing overseas. Because if you are manufacturing in China and all you have is U.S. patents, and you have a big market in, say, Japan, there's really nothing you can do, because you have no Chinese patents and you have no Japanese patents. So you're kind of stuck. So that's the case, the far extreme case, where you really need to think about that. Now, the good news is, now your foreign filing, you do have to have a foreign filing application, or foreign application within 1 year of the provisional, just like the U.S. non-provisional. So just to clearly say again, if you would file the U.S. non-provisional a year after the provisional, that means you're kind of filing your foreign application at the same time. Now, when I say foreign application, and I don't want to get too the Paris Convention filing, 99 out of 100 take advantage of this piece. It's like a provisional a little bit, and that buys you another 18 months after the filing of the U.S. non-provisional, assuming you waited the full year. And I have a chart after this to kind of help clearly state this, because it does get confusing. And then one other thing to think about, and this is why things get so expensive so quickly, you got to file, ultimately you've got to nationalize each application in each individual country you want protection in, and you got to prosecute in those individual countries. So whatever it's costing the United States, you pretty much multiply that number by the number of countries you're nationalizing in. So it gets really expensive really quick. So I guess here's the quick map to just take you through it left to right. The PPA, that's just provisional. So you can file one to n number of provisionals. Within a year, you need to file a U.S. non-provisional. At the same time, you would need to file, again, typically, I'm using the PCT as an example. You could also file under another convention that we won't get into. But the PCT, though, on that upper track, that provides another 18 months of protection, but put another way, that's 30 months from the first provisional filing date. So 30 months from that early provisional, that's quite a bit of time. And so that's why people use that PCT, is it really provides some really nice long placeholding protection. So within 30 months, you really would hope you're at the point where you know whether or not it's worth nationalizing. So you got that 30-month time window, make the decision. At the same time, your U.S. case is going to be prosecuting in the United States. When I say prosecuting, that's just the process of, it goes to USPTO, attorney, patent office typically argue back and forth a little while, really just determining whether or not your invention is patentable. Then ultimately you nationalize in the individual countries, and you go through that same process with that prosecution process in every national country, or every foreign country. And I will say there are some mechanisms that the different offices cooperate, and I won't get into those, but there are just some tools that, for example, the European office will work with the U.S. office, and it just helps with efficiencies across the world. And usually, in a lot of cases, foreign offices will follow what the U.S. does, kind of copying what the examiner in the United States did. But to quickly go through some of these cost-saving, nuggets that were kind of buried in some of those slides. I wanted one slide to kind of help kind of collect them. The one thing that I didn't really get into much, but timing of your application is important. The one thing I try to tell people is don't file too early. Now, as an attorney, it's hard for me to say that. It's hard for me to say don't file, because if something happens and you didn't file, that could be problematic. But I think there's a balance between, you want to file as quickly as you can, but there is such a thing as filing too early. So you really want to file as early as reasonable is what I would usually say. And the reason I say that is as soon as you file, you're starting a clock. You're spending money and you're starting a clock. So I always tell people a good time to file is when you really have made some good progress on your prototype. When people come to me and it's just kind of an idea in their head and they haven't even done anything with a prototype, I usually tell them it's too early. I'm happy to go forward with them if they want, but I really want them to understand that the risk and constraints they're putting on themselves because that clock starts. Now, if you wait until you kind of have a good prototype put together, then a lot of those details that go into making that prototype are the exact details which will get you the patent in the end. And if you haven't gone through that inventive process, the inventive process truly isn't just the idea, right? It's not just the idea of this widget. It's the reducing that widget to practice and really developing that content. And that is what's really, really valuable in terms of patentability. And so if you time it so that you're really starting that patent process, right about the time you're getting your prototype put together, that you've delayed the filing, you've push off costs for a while, and then you really developed a lot of good subject matter that will make for a really rich patent application. And I'd also say, just from experience, and this isn't a rule because there's always an exception, I would say 9 times out of 10, if not 99 out of 100, you're not really worried about what other people are doing. It's rare that somebody just barely beats you to the patent office. It really is. Usually when art is cited against you, I'll talk through that in a second, what that means. It's something that happened a long time ago. It's rarely something that happened 2 months before you filed. Now, it does happen. It absolutely happens. But that's not usually the biggest concern. The biggest concern is what you're doing publicly. So and that often what you're doing publicly is what's driving when you're going to file. And I'll kind of lay that in a couple slides here. So that is the balance that you need to think about. Obviously we've talked about design applications as a nice alternative. It doesn't always work. There are inventive areas that just design applications make no sense, but that's a conversation you should have. Doing either your own search or at least part of your search, kicking that process off on your own, and then collaborating with an attorney that will work with you. Some do and some don't, where they will let you kind of start the provisional drafting process off on your own. And then, really, really diligently analyze whether or not you need foreign filing needs. I think some startups get to the point where they kind of just conclude, yeah, let's just do the PCT, and that PCT filing fee, by the way, is about $3,000. That's just the government fee to do that. They do that just because they think they need to do it, and maybe they haven't really thought it through. And I always really want to try to make them do that. Now, there are times though they have an investor that says, yes, we need to file a PCT, and if that investor, if he or she is writing checks, then that's usually a good reason to file a PCT. So that often is a driving force. And then I guess the last point is I think common sense, which is just be proactive. The sooner you get out in front of problems or questions, the sooner you can get on top of it. It helps your attorney know what your needs are. It also allows you to maybe do some of that work on your own, at least at the outset. Whereas if you come to me or another attorney and say, hey, I need to get this filed in a week, there's not much time for you to do much front-end work that might save you expenses. So be proactive, always ask questions, get involved with an attorney early on. It's no big deal for an attorney to have a conversation about a potential patent and then that person not actually go forward with the patent for 2 years because they're working on a prototype. That's very common. And an attorney should not have a problem with that. So that's a nice list of things just to think about. A lot of them are common sense, but I wanted to consolidate that there. Okay. So, we've been through I know I'm talking pretty fast. I'm trying to get through all of this for you, but we've been through what types of things can you protect, from utility type applications to designs. We've talked about the patent process itself, what that looks like, some cost saving measures. The next piece is really what this gets I don't want to say technical in a legal sense, but it's at least relays to people what actually goes on in terms of analyzing whether I can get a patent or whether I get a patent. And that's these 4 sections of the law, sections 102, 103, 112, 101, are essentially what the patent office analyzes. So what happens is you get a patent on file or patent application on file. So you've gone through that process. You've done the provisional, you've done the non-provisional, you filed it, it's off to the patent office. And, at that stage, I always visualize it as this, some 1920s clerk in an office with papers stacked really high, and, yours just goes to the bottom of the pile. And it kind of still works like that, maybe digitally, but, it goes to the patent office, it goes into the queue of an examiner, and eventually they get to you. And when they do, these are what they analyze. They analyze whether or not your invention is novel, non-obvious. They then analyze your description of the invention, which we didn't really get into, but you have to provide a description of the invention along with drawings. They analyze whether or not that description is adequate. Basically, is it good enough to support the claims and enable the claims? And then the second, or the 4th box is kind of for the longest time, it wasn't all that important, but it's more important now in the era of software and genetics and that. It really is a subject matter eligible for patenting. So it doesn't matter whether it's new or not, or new and non-obvious. It's does the government, this question is really, does the government allow people to have patents in this space? And I'm not really going to get into 112 and 101, but just understand those are requirements that exist. 112 is really not something most inventors need to worry about, because that's really more of a requirement on the patent attorney, making sure that disclosure or that description and the drawings and all that are adequate. 101 is something you have to worry about if you're in the software space, and that's something that you just have to work through with the patent attorney to define whether or not it's what you're working on is patent eligible. The most important pieces are 102 and 103, novelty and non-obviousness. And to really just give you an idea what those are, novelty, I think everybody comes to the table having a gut feeling about what that is. And it starts off with this kind of comment. Hey, Matt, here's my invention. I've really looked all over the place. I've Googled it everywhere, and nobody else is doing this. I'm sure I can get a patent on it. That's kind of how that conversation goes. And that's good. That's a good threshold. It's good that nobody else is doing it. But one of the things that some inventors have a struggle with, at least initially, is this idea of non-obvious, this non-obviousness requirement. It's an extra requirement on top of novelty that kind of adds another layer of complexity. So what ultimately, the way this just very practically works, so just assume that we've overcome the novelty piece. What really happens then is you look at all those limitations, and we're talking about a utility application right now. If you go back in your head to those claims that I showed you, or that claim I showed you for the bike, what the patent office does is they look at those claims and they go search their databases for patents that are similar, in terms of the invention, and they will compare your claim to those pieces of art they find. And the difference between your art and what they find, the difference between your claim and what they find has to be novel, which we're assuming we've overcome, and non-obvious. And so the non-obvious piece, as I mentioned, is what confuses people, because the patent office can actually, their definition of obvious is not really obvious, frankly. So it's confusing to people. It's not, everybody thinks their invention is not obvious because it's inventive. Well, of course it's not obvious. If it was obvious, people would be doing it. And so that's the way that the patent office looks at this. Is something is obvious is based on the understanding of a person having ordinary skill in the art. If that person would view your claimed invention as obvious relative to the art that the examiner found, then they will give you what's called an obviousness rejection. The mirror image of that is to establish non-obviousness, we have to show that it would not be obvious to someone of ordinary skill in the art. And so that definition is very fluid. It's in the eye of the beholder. The examiners have different opinions on what that means. B, the case law on this changes quite a bit. And so unfortunately, there's a certain gut call to this, and that's kind of where patent attorneys come in. They see this, we can clearly tell whether or not something's novel. That part's pretty easy. It's this obviousness piece that's the fuzzy. I try to graphically just describe it as this fuzziness around all the art you found. There's like some fuzziness around it, and that fuzziness is what we have to navigate. And usually, I would say most times, we are able to overcome something like this. Understanding, of course, that we are not filing the applications that are clearly obvious, and we're doing some filtering on the front end. Once you've done that, in most cases, you can get this through. But it's just something that inventors sometimes struggle with at the outset. And frankly, examiners struggle with it too. So that's kind of the high level, what standards are out there that you have to worry about. And then, the other, and I wish I could have fit this in earlier, because this is a really important slide. I mentioned earlier that 99 times out of 10, it's your own efforts that end up creating problems in terms of timing, in terms of filing that patent. And this is why. So, all of the 102 and 103 things I just mentioned, the novel, non-obvious pieces, they apply to your own activity. So your public disclosure, your public use, your offers for sale, all those things fall under that. So what you're doing, usually the person that is you, because what happens is you're developing this product, you're wanting to go put on a website, you're taking it to startup pitches, for example, conferences, trade shows, sometimes grant applications can be using it in your business. Maybe it's a new tool in your business and you're using it in your plant or in a construction area or wherever it is. That can be a problem. And one thing I'd add, one really important point is public use doesn't have very secret public use. I mean, an example would be like a new carburetor on a car. Nobody can see it. Nobody knows it's there. But if you're driving around on that in the way you would normally use it, and you're not experimenting, that would be or could be considered a public sale. As the U.S. has a 1-year grace period. The bad news is most foreign countries don't. They have what's called an absolute novelty jurisdiction. So once you start practicing or publishing that invention, you're pretty much your foreign rights are heavily impaired. So what general best practices are: don't ever rely on this 1-year grace period. That's only a backup if you come into the office. Hey, 6 months ago I started selling these. What can I do? Well, good news is you can probably still file for U.S. patent. Bad news is your foreign rights are probably in trouble. And on top of it, if you're selling a product and it's doing well and you haven't filed a patent, other people can see that and then they can go potentially and kind of co-opt some of that subject matter and hurt your ability to file on a patent down the road. So general practice is always get a filing date in place before you do anything public, but recognize there are some backup options if you need to. So this is a very important slide, and at some level, if nobody takes anything else away other than this, that would be good, because this is where you can cause some self-harm, and that we don't ever want that. I guess just to wrap things up pretty quickly, we've been through a lot in about 50 minutes. From what we can get patents on, how the patent process looks, some cost-saving efforts. All of that, the standards at the patent office. The final question is, you get a patent, what do you do with it? Like I said at the very outset, if you're a 2 or 3 person startup, you're not going to be able to do much, right? I mean, patent litigation is extremely expensive. But your options generally, as you grow, you have federal loss. You can file a federal lawsuit. You can, of course, file counterpart lawsuits in foreign jurisdictions. One newer avenue is the International Trade Commission, which is basically it's an administrative judge presiding over this international trade court, and they will take up your case, kind of acting on your behalf. It's kind of it's a pseudo judicial process. But you can't really get damages. You can't sue for money, but you can get in cases where a competitor is importing products from a foreign country, you can get you can get those products stopped at the border. And then the final one, which is to me really interesting nowadays, is kind of the quasi-judicial tools, which are really just private companies like Amazon that are selling. They just have these huge footprints. Well, they have a process that looks very judicial, that allows you to kind of shut down a competitor if you can provide kind of a prima facie case of infringement, which is, and this is why I'm going to go back to why designs are important. So hopefully this kind of comes full circle, and why I was talking so much about designs early on, is for things that lend themselves to design applications, you can take that design application, which an ordinary observer can analyze, which is probably a manager at Amazon, looks at the product that the potentially infringing product. They look at the picture of your design, and they look and make a determination. It's like, oh yeah, that's pretty close. I'm going to push this button. I'm going to shut this guy's sales down until he can prove that he doesn't infringe your patent. So you shift the burden onto that seller, and that's a really cost-effective way that you're not going through federal litigation. You're sending some stuff to Amazon, and it's a really cheap way to get some decent protection. And if this day and age, with so much of everything being sold through the likes of Amazon and other avenues, it's a pretty nice tool. And so it does, that's a little harder to do with a utility patent for sure. But I'm not to say it can't be done, but designs for that purpose are great. And so I don't want to say all this and just suggest you should do design instead of utility. Utility is the holy grail in patents, but always consider doing designs as an alternative when utility is really hard to get, or as a backup option, or another layer of protection that you could use to augment your utility protection. So there, I was talking really fast. I covered a lot of stuff. I don't know how many people are actually still on because we were having connection problems. So hopefully there are a few. If not, you have a recording. It's open for questions. If you have questions, of course, email me. I'm always pretty reachable. There's a lot of familiar faces or names on this list that I've already know. Of course, always reach out. I'm always available for a chat. You have my email address on this page, our website. Yeah, so let me know if you have any questions. Sorry I was so fast.